Good afternoon, everyone, and welcome to today's panel discussion, Should I Stay or Should I Go Again? Public Service During an Unfriendly Federal Administration. I'm Zanelle October, Executive Vice President of the American Constitutional Society, the nation's leading progressive legal network with over 200 student and lawyer chapters in almost every state and law school around the country. Through our diverse, rapidly growing nationwide network of progressive lawyers, law students, judges, scholars, advocates, and many others, ACS's mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy, uphold the rule of law, and realize the promise of equality for all. If you aren't already, I'd encourage you to become a member of ACS and to donate. Our work is more important now than ever, and we need your support. Please go to acslaw.org where you can join, donate, and find more information about events like this one. A couple of housekeeping notes before we begin. We are not offering CLE credit for this event. This afternoon's discussion is being recorded, and the recording will be available at ACS's website after today's program concludes. There will be time during today's discussion for audience questions. To submit a question, please use the Q&A box at the bottom of the Zoom screen. In 2017, ACS hosted a conversation to discuss the pros and cons of public service during the first Trump administration, which had already begun to put our institutions through their greatest stress test in modern history. And now we find ourselves here, as our title points out, again. As a nonpartisan organization, ACS neither supports nor opposes political candidates for public office, but different public office holders may better reflect or contrast with values that comprise ACS's guiding vision of a country in which democratic institutions, the judiciary, and civil legal society advance equity and justice, uphold the rule of law, and guard against abuses. All of us who are part of the ACS network and everyone who supports our work shares the belief that the law can be a force to improve the lives of people. Many of us have used our skills and roles as lawyers, whether through career choices, pro bono work, or engagement with our communities to bring those values to life. And public service, service in the name of the people as part of the government, can be one of the most noble ways to put those values and beliefs into practice. And yet many of our progressive colleagues, including many of you on this call, now face what may be an agonizing decision. What obligation, whether personal, moral, or to your community, do you owe to remain in public service during an administration that may actively seek to do harm to your communities and to the foundations of a pluralistic multiracial democracy? Can your and other attorneys' continued service help to mitigate some of the worst damage or reveal potential malfeasance that may occur? What if a new Schedule F executive order is issued by the incoming administration removing civil service protections for the position you may hold? Or if continued service in an unfriendly administration comes at too great a personal or professional cost for you? What are some other ways that you and all of us might spend the next 4 years supporting the progressive legal movement and defending against the worst impulses of a second Trump administration? These are hard questions, and questions that we'll be grappling with repeatedly over the coming years. But I'm so proud that ACS can help us begin addressing these questions now before day one of the next administration. And I'm humbled by the group of impressive speakers who have agreed to help us begin this complicated conversation. It's now my pleasure to turn this over to my colleague, Valerie Nannery, Senior Director of Policy and Program and Coordinator of ACS's State Attorney General Project, who will lead today's discussion. Valerie.
Thank you so much, Zanelle. I am thrilled to introduce our fantastic panel of speakers who will help us walk through some of these difficult questions. Jill Habig is the founder and CEO of the Public Rights Project. Before founding PRP, Jill was the Deputy Campaign Manager and Policy Director for Kamala Harris for U.S. Senate and served as Policy Director for her transition team. Prior to joining the campaign, she served as Special Counsel to then Attorney General Harris, advising the Attorney General on key legal issues and policy initiatives. She was previously a lecturer in law at Yale Law School and served on the Affirmative Litigation Task Force at the San Francisco City Attorney's Office. She is currently a lecturer in law at Berkeley Law School and teaches state and local impact litigation. Barb McQuaid is a professor from practice at Michigan Law. She also serves as a legal analyst for NBC News and MSNBC and has written for a wide array of national publications. From 2010 to 2017, Barb served as the U.S. Attorney for the Eastern District of Michigan. Appointed by President Barack Obama, she was the first woman to serve in her position. Before becoming U.S. Attorney, Barb was an assistant U.S. Attorney in Detroit for 12 years, serving as Deputy Chief of the National Security Unit. Jennifer No is Ruth Wyatt Rosenson Professor of Law at the University of Chicago Law School, where her main research interests are in administrative law, executive branch dynamics, regulatory policy, and constitutional separation of powers. She is a senior fellow of the Administrative Conference of the United States and a former advisor at the Office of Information and Regulatory Affairs. And last but certainly not least, Joe Spielberger is the policy counsel at the Project on Government Oversight's Effective and Accountable Government Team, where he advocates in Congress and the executive branch to strengthen whistleblower rights, protect a merit-based civil service, and promote government ethics and transparency. Prior to joining POGO, Joe worked as the public policy counsel for the ACLU of Maryland, and he previously worked in state and local government for the Maryland House Judiciary Committee and the Baltimore City Mayor's Office of Human Services. So here we are again, and President-elect Trump has already announced a number of terrifying policies, many of which are unlawful and unconstitutional, or at the very least, wildly diverge from the moral and ethical standards of many of the people on this call. Barb, I'd like to start with you. What lessons can the first Trump administration offer current federal employees as the shape of the next presidential administration comes into focus? And can continued service in the federal government mitigate the worst damage?
Yeah, well, thanks very much for inviting me to participate in this conversation. I think it's so incredibly important, and I recognize that for all of you, this is going to be a very individual decision. But I was still at the Justice Department when Donald Trump took office in January of 2017. And I think there are maybe two lessons to draw from that. One is, for most people in the federal government, the work did not change. At most levels, people are doing good and important work on behalf of the American people every day. And that's going to be the same regardless of who's in charge. For other people, though, it did change considerably. I'll give you one example of how it changed for me immediately. I was there until March when President Trump fired the lot of us. In January, you may recall, he issued his Muslim travel ban. It was the first of 3 iterations, and in its first iteration included a ban on lawful permanent residents. These are people who had due process rights to enter the United States. And so it seemed to most of us that it was on its face unlawful. And so it came in the door. We had a case filed in the Eastern District of Michigan, and I sat at a conference table with colleagues to discuss how we would handle this. And, on the one hand, I think that every government program has lawyers, and if there is a legal argument to be made as lawyers for the government, it's our obligation to do that if you can make an ethical, good faith argument. But on this one, we thought we couldn't. And then it was that night that Sally Yates said, "I'm not convinced that this ban is constitutional. I'm hereby directing the department to not enforce it." And I had a great sigh of relief because I wasn't quite sure how we were going to handle that. And then, of course, she was immediately fired for that act of defiance. And it was then that I realized this is going to be a very different animal than we've experienced before. And so I think for some people who found themselves in a position of defending something they found indefensible, I think you have to ask yourself whether you want to be part of that. I think most of us choose to work in the government because we want to help people, we want to serve, we want to make our communities better. And if you are asked to do something that you find lawless, then perhaps you should be thinking about doing something else. On the other hand, if there is a legitimate legal argument that can be made, I think it is the job, even if it's not your personal preference, I think it is the job of public servants, of government lawyers to defend those things. Now, that was the first time around. I think the second time around might be very different. The first time around, most of the people in leadership positions were, although they may not have shared my political views, were not willing to be lawless. And so far, some of the things we've heard from, Donald Trump's nominee for Attorney General and for the FBI director are saying things that are very concerning to me. And so, if you're inclined to stay, I'd say, hold tight and see what happens. Is this just a lot of bluster? Or are they going to direct people to file lawless lawsuits and indictments? And even if they do, I think it'd be really important to have people of integrity in place in the Department of Justice and elsewhere to stand up and say, this is wrong. I realize it's easy for me to say that now from the outside. I'm not the one sticking my neck out. But if all the good people leave, you will be replaced by people who are willing to carry out those illegal orders. And that's where I worry that we can get into real trouble in this country.
Jennifer, do you have thoughts on whether there are roles or agencies where the calculus of whether or not to continue with federal service is different than it might be in the Department of Justice?
Yeah, I mean, yes, and I think that I'm going to fold that into also kind of the larger question about how folks in those other agencies can work on different agency actions, whether it's regulations or otherwise, to help ensure that they comply with the law. So, I mean, at a broad level, I think, just as Barbara suggested, that there's going to be a lot of variation across agencies in terms of like the appointees, like the extent to which they're going to push boundaries, to say the obvious. And then there's probably also, I mean, obvious important differences between like executive and independent agencies as well, right? Like the calculus and the influence. Hopefully some of those norms hold, but a lot of their structural protections, obviously, as well, that I think will also, play a role in everyone's kind of personal thinking about this. To Barbara's point, I mean, just as Barbara says, as a member of the public, it's easy for me to say, please stay. But I am a firm believer, as I think most of us are, that, just an effective administrative state, grounded in science, facts, and laws, like really needs like principled, expert, civil servants like so many of you to, persist across administrations and faithfully serve political appointees whom they may disagree on policy grounds. And the question, I think, for us in this conversation just becomes, when does that bleed into something that is clearly lawless and, whether it's statutory, constitutional, and so on. So with that said, just a few thoughts. I think a lot of recent Supreme Court decisions, despite expanding presidential power, think, immunity, think removal, I think some of the recent decisions actually also constrain presidential power in ways that I think will empower your work within the agencies. So, for example, like Loper Bright, right? It's now going to be calling for kind of all of your best interpretations of the law, right? Rather than, whatever White House counsel, just the political interpretation of the law, Ohio versus EPA, of course, much harder look arbitrariness review, which I think will support all of your good work in making sure that the record, accurately accounts for question, fact and evidence as submitted from public comments and studies and otherwise. And so I think there is more room now for civil servants doing the good work that you have done in the past to get external support, doctrinally at least, in the courts to check the worst excesses, right? So of course, that means explaining really well, in the internal deliberations, your conclusions of law, science, and fact. And I think importantly, creating a record as you do so, because I think, recent Supreme Court decisions, I'm thinking Department of Commerce versus New York, suggest that Supreme Court might be more willing to rebut the presumption of regularity, look beyond the agency decision to look at, everything else that's in the record, like as a basis for review. So I think there's a really important role for that documentation to continue and be elevated. And, I think the first administration, is any harbinger of what's to come in terms of the court's behavior. I'll just throw out there that, by one measure using data, this is constructed by Policy Integrity. They found that agencies during the Trump administration had a 70% loss rate in litigation, 78%, of a lot of the challenges to agency action, suggesting, I hope not too naively, that there is still a role for the courts. Now, of course, much has changed since then in terms of the makeup of the courts, in different directions. And I think a lot of the extent to which we can rely on courts will depend on so many things, such as, the extent of forum shopping and, on the other side, to bring a lot of these abuses to light and actually have the court serve as a bulwark. The second just quick thing I'll just say is I think there are more difficult questions that arise when political appointees like sideline or worse, doctor input or just cut you out of the deliberations, which I think the first administration we saw a lot of, where you can't actually do the good work that you do as civil servants. And, I think I'm sure in our conversation, we're going to talk about more other avenues or things that you could consider doing to make sure that input is heard, particularly once again, in what I hope are the narrow circumstances where there are, again, just clear legal violations. And I emphasize that because I hope that nothing that I say is going to be misconstrued as endorsing resistance just on good faith, reasonable legal disagreement or policy disagreement or anything like that. And, if it's useful, I think, in the military, just to note that, the military, the most hierarchical governmental body there is, they acknowledge that there are situations that don't require acquiescence, right? And they use the same standard of clear legal violations. They use phrases, the case law uses phrases like they don't require situational judgment. Barbara said illegal on its face, when there are, qualified immunity also gives you some, other principles for thinking when something is a clear violation or not, when there's just no debate about the statutory or constitutional question. I think I'll just pause there because I know we're going to discuss more of the avenues of what to do in those circumstances, but I'll just kind of throw out, that I think it involves a lot of consulting with other allies and other agencies. We'll see, it'll be difficult, but, there are, there's strength in numbers. And of course, there's inspectors general. I know we're going to talk about whistleblowing statutes. And then we'll also, I think, say a word or two just about your own union grievance procedures as well, which there's a lot of contracting.
I think you may have already addressed some of what I'm thinking about when it comes to the administrative state, your area of expertise. When you're thinking about Loper Bright, you're thinking about the administrative challenges during the first Trump administration. You're correct. The Institute for Policy Integrity did show that the first Trump administration only won 23% of the time. And when they litigated against the states, they lost even more often. When the states brought challenges, they lost 83% of the time. For the attorneys who are working within agencies where the heads of the agencies seem to have a mission that is hostile to the agency or department, and with this incoming administration, they seem poised to continue this attack on the administrative state itself. Use Loper Bright as a tool to undo past regulations. Do you have advice for how attorneys who are working on the regulations can ensure that they comply with the law, stand as a bulwark against the worst urges of the leaders who are not inclined to serve the mission of the agency in the very first place? And if you feel like just see above, you can add a little bit to that, and maybe one of the other panelists, if you have thoughts, you can chime in.
Yeah, I mean, there's a little bit of see above. I mean, in the sense that I think that the idea of like mission is so hard and complicated, and it's I guess my instinct is to just tie that to very closely, see Loper Bright, to the actual like statutory language and so on. And I wonder if there are resources, from cases like Heckler versus Cheney, because like obviously administrative agency heads like have discretion, of course, not to enforce statutes to the fullest. And I think we all recognize that. But I think that, footnote 9, Heckler, there's like, when there are clear abdications, of statutory responsibilities, there, I think, to your point about mission, I think that there is more of a role for lawyers to push up against that. And, all of you know even better than I'm sure all those resources, but heckler does seem like one place to potentially start.
Give any of the other panelists an opportunity to jump in. Jill.
Yeah, I just have a couple of things. I think I really agree with everything that's been said, and that any of us, all of us who have served in government know that there's a difference between our personal policy or political preferences. Our job is to serve the elected and administrative heads of the bodies that we work in, and that often means working on something that might be different than what we would choose to do if we were in charge, and that is part of the work. And that there's a difference between that and sort of legal and ethical lines. And so, one thought is you have a moment now where you have the luxury of thinking about how you might act before you're in a position of having to be under pressure to act in a certain way. And so, thinking about what your bright lines are, ethical and legal lines that might be crossed in your line of work, wherever, you sit within the federal government. And then also for personal sake, your own moral lines, right? As much as I think all of us would hope that folks can stay and continue to serve in the federal government, no job is entitled to your service. And so, thinking about what are the lines that you're not willing to cross, and even, memorializing those in advance might help you think clearly when you're in the middle of a potential crisis in your job. And so, I think that's one way to think about how you can prepare for your obligations, and where, when the lines are that you no longer want to fulfill those obligations. And then we'll talk later about kind of other ways to, if you do feel need to exit or sound the alarm, what your options are to do that lawfully through your union or through whistleblower statutes.
That was perfect segue into talking about what the people who continue to work for federal government, if they are asked to do something unethical or illegal, what protections do whistleblowers have? What other legal protections should federal employees know about? Joe, you're a resident expert on this panel. Can you address some of those questions?
Yeah, definitely. So most executive branch employees are covered under the Whistleblower Protection Act, which does explicitly prohibit retaliation for refusing to violate a law, rule, or regulation, as well as other protections against retaliation for exercising appeal rights, grievance rights, cooperating with an investigation, and certainly making protected disclosures of violations of the law, gross mismanagement, abuse of authority, etc. That includes disclosing information to Congress, Inspector General's offices, up through the chain of command to the media, to NGOs, etc. There's certainly a lot of exceptions to whistleblower protections, especially for employees in the intelligence community, people working for the legislative branch or the judiciary, but regardless, there's a huge difference between having rights and protections by law on paper and actually, seeing how those protections are respected and enforced. So for covered employees under the Whistleblower Protection Act, they can bring claims of retaliation either to the Office of Special Counsel and or the Merit Systems Protection Board, but there are also real limitations in doing so. So for example, the Office of Special Counsel, they can investigate retaliation, they can make recommendations to the agency to take corrective action, and they can seek enforcement of those recommendations through the Merit Systems Protection Board. But at the same time, it's also a really small agency with limited resources. And so they're only going to take on some of the most egregious examples of retaliation and where there is the clearest evidence. And then in terms of bringing claims to the Merit Systems Protection Board, one of the big issues there is that historically speaking, whistleblowers prevail on the merits of their claims at very, very low rates. There's not very clear and reliable data, but where there is, it really looks like, on average, anywhere from 2% to at most, 8 to 10% of whistleblowers are actually winning their cases in front of the MSPB. Another huge issue is that regardless of the outcome, these cases can take years or even a decade or more. And so that not only leads to financial issues, but, certainly the ongoing emotional and psychological turmoil as well. And so whenever we're talking to different audiences about their rights and protections, we try to be very clear about not just having these rights, but having the right to make a very informed decision. And so that includes really getting a better understanding of what you are likely to face in going through this process. And I'll just add that, again, one of the challenges is that whistleblower laws are scattered. It's really like a patchwork, scattered in a lot of different places. There are so many different loopholes and other issues. But one thing that I would encourage folks is, you can go to our organization's website, pogo.org. Another great source of resources and fact sheets is the Office of the House Whistleblower Ombudsman. They have a really great just series of one-pagers and a lot of information about different sectors, different agencies, etc. So I'd really encourage folks to become familiar with some of those resources that are available.
Thank you so much, Joe. Can any of you speak to the levers of power that federal employees have, either as just employees through their unions or as private citizens? Everyone, lives and works here and has a First Amendment right. How can they use those levers of power to oppose or fight against hostile leadership? Perhaps Joe could start and Jennifer could chime in.
Yeah, I'm happy to start with this. First of all, it goes back to, I think what Barbara said up front is that, of course, all of these are very, very personal decisions. That being said, I think there is a lot of power in mass resignations and principled resignations, not in advance of anticipated threats, but directly in response to things that you're being asked to do or things that you're being prevented from doing. Going along with that, a lot of former Trump administration officials who did resign, wrote letters and op-eds, really being clear their thought process and how they made those decisions based in very moral and ethical grounds. Another thing to do is, work on building relationships with journalists, congressional offices, NGOs, et cetera, not necessarily to blow the whistle, but perhaps as a source of information with a lot of the same, caveats and concerns about, being mindful of secure communications and protecting your safety. But the last thing that I'll emphasize, which might sound really simple, is just talking and sharing publicly more or with people in your communities about the important work that you and your colleagues do. There's so much, there's certainly so much disinformation, and rhetoric about the deep state and everything like that. And what the research and polling shows is that while, generally speaking, people have a really negative view of the federal government writ large, when you start to kind of peel back that layer and ask people about specific agencies and people doing specific work, and people's personal experiences of interacting with federal civil servants, most people have a really positive view of that and the benefits that they receive, and those personal interactions that they have with agencies. And so I think just sharing that information out can be really, really important in kind of shifting the public narrative about the importance of the civil service and all of the important work they do that plays such a positive role in communities across the country in terms of all of the services and benefits and protections that all of us rely on to live our lives.
Yeah, I don't have much to add. I think Joe had so many great suggestions to, Valerie, I take your question to be, how to get some of the information, out into the public, whether it's through whistleblowers. I mean, I guess the only piece that I'll try to say like a couple seconds on is just, to go back to the importance of unions. And if we just look at all of what unions have done in past administrations, so under the Obama administration, of course, ICE and the unions were so involved in suing the administration. But then in the first Trump administration, in contrast to Obama, the EPA's union was so active. They spoke publicly about, internal agency operations. I remember they criticized publicly criticized, a lot of what the administration did with regard to enforcement. They also lobbied against deep agency budgets and budget cuts. And so the point is I think that there are a lot of avenues under labor law that protect that. And so I would really urge you to become more familiar with your specific union, because of course, different agencies have their own CBAs that are unique to them. And I think a lot of them over the years, I think have managed to negotiate pretty substantial protections for, that kind of speech getting out into the public.
We have so much more to cover. So I do want to turn to Jill. If someone chooses to leave federal service or is forced out, Schedule F, or whether it's, this RTO mandate that we anticipate coming down the pike, with forced attrition in the federal executive branch. What are some options for lawyers with federal government experience to continue serving in public service? And I'll start with you.
We've reached my favorite topic. So I think the short answer is there are so many options to serve in state and local government, as well as in, a number of organizations that work directly with government and on public interest advocacy work. And so state and local government, and the first, just to start with, I know a number of attorneys general offices, state agencies, and local governments are, already posting new positions or will be in the coming months. And so the California Department of Justice, I know, has posted a number of new positions in their civil rights enforcement section, for example. Federal experience is extremely helpful for that section because they do a variety of both affirmative civil rights investigations, as well as litigation against Trump administration actions in the first Trump administration and other kind of federal government overreach. I would expect the New York, Massachusetts, Michigan, Illinois, and Washington State Attorney General's offices to be posting positions relatively soon. I'm sure I missed a couple of offices, North Carolina and others that have really strong contingents of both litigators and advice lawyers, where federal service would be extremely valuable to the work that they're doing. And then I would also really urge folks to consider local prosecutors' offices, county prosecutors, as well as city attorneys' offices. For example, I know city attorneys and county counsel's offices. Those offices, we work with them at Public Rights Project. We work with several hundred city and county attorneys' offices, and they do really interesting and impactful work in the community, from affirmative litigation to, making the government work and function for people in the same way that the federal government does. And so I know of, positions that will be posted soon in Chicago, in Philadelphia and surrounding counties, in San Francisco and others. And so I do think those are really strong options for people to consider with a wide range of federal government experience. And I think from the conversations we've had with local governments, even just since the election, I think they really are interested in thinking about two paths. One is making sure they're equipped to push back on any lawlessness from this administration and threats to communities on immigration issues, on public health, et cetera. And that they are really committed to filling some of the gaps that they expect to be left by this administration on issues like worker protections, consumer protection, police accountability, and civil rights enforcement. So I think there are a lot of opportunities both to leverage your federal government experience to combat some of the overreach of this administration that we expect, but also to continue to actually push forward on, areas that you have subject matter expertise on. So I think, consider all of those options, and I'm very happy to connect folks or speak to folks offline if it's helpful. And then I would be remiss if I didn't mention that, we will be hiring at Public Rights Project for attorneys and litigators. I also know of a variety of organizations from Protect Democracy to Democracy Forward, States United Democracy Center, and others that will be staffing up soon. And so I think there are lots of options available for meaningful work if you do choose to leave federal government service.
I do also want to plug the State Attorneys General Project at ACS. We have employment resources for current law students, law clerks who are looking for opportunities in State Attorney General offices. Many of those opportunities for the coming year have closed, but some have not yet opened. And there are also opportunities for summering in state AG offices. And so please check out our page on the ACS webpage. But I wanted to invite anyone else on the panel to comment about continuing public service in other ways. If you have additional thoughts or given your experience, how rewarding that can be, even if you're on the outside of the federal government.
I'd just like to offer a thought just quickly. It's not exactly your question, but a little bit on timing. Because so many of these opportunities that we've talked about are open now, and I imagine there will continue to be openings. But just as all of you think about keeping your professional networks alive so that you know kind of what's open and available in the coming years, I just want to mention that for those of you that understandably and rightly are fearing and Schedule F in another form. I'm sure most of you are aware, but just to kind of put it out there, as in the Biden administration, there was an OPM rulemaking that severely limits the legal arguments, kind of blunts the effects of Schedule F. And it's going to take time. The Trump administration called it a roadblock, but it's going to be a roadblock before that rule gets reversed, if it does, and the litigation itself, in other words, will just take time. So I think that before any new version of Schedule F, at least in the first version, there could be a modified version, of course, really is able to get passed or come, whatever the rulemaking, there's some of these rules to be challenged, will or rather to deregulate with another rule, could take up at least a year, if not more. So anyway, just as you think about timing, I just want to throw that out there.
Can I just add really quickly, because I really appreciate Jennifer bringing up this new OPM rulemaking. And one important piece to just add on that I want to emphasize is that those protections are only there for folks who are involuntarily transferred. And so there could be people approached, in a way that this is an opportunity to transfer into a new position. But I think it's important to be mindful that doing so, you would lose the protections that are in place, at least until a new or revised Schedule F is implemented.
I think that Jennifer's point on timing is incredibly important, because I think that some people are feeling a great sense of urgency right now to just find some place to land and figure out where that is. Your work, your experience, your dedication to public service will continue to be needed across the board. It looks like Barb has a thought to share.
Yeah, I just want to add, it takes a really long time, I think, for any of these things to be implemented. Everybody who's worked in the federal government understands that things move slowly for a reason. It is by design. It is to avoid radical change that might be disruptive or cause instability in government. And so I think that if I were advising like my best friend or my child about what should I do, I'd say like ride it out for now, see how this goes. I think there's going to be a pretty massive defection from government service anyway, from political appointees. And so, a lot of jobs are going to get filled by those people. You might be wise to just kind of ride it out. It's probably, even if the worst comes to pass, it'll probably take a couple of years for that to happen. But I really think that even the worst is likely to affect only a very small percentage of the federal workforce. So you might just ride it out and see how things go, because I know 4 years right now seems like a very long time, but from where I sit, 4 years is a very short period of time. And I think in 2 years, there could be a very different climate at the midterm elections. So if you can ride it out, there might be great value in that. Again, as a citizen of the United States, I have a strong desire to see professional civil servants work throughout administrations and not, come and go based on the political whims of who's in office. Although I recognize that this is a very different set of rhetoric than we've heard before.
Well, there is a question in the chat that I'm going to incorporate into the question that I have for you from many of our participants in today's call. What advice do you have for current law school students, recent law graduates, judicial clerks who are considering whether to intern for federal agencies next summer or apply to, or even, actually join the federal government where they've already accepted a position but have not yet started? What advice do you have for them? And that's a free-for-all for all of you.
I mean, I think consistent with a lot of the themes we've heard, again, acknowledging where we sit, but I mean, the federal government is such a rewarding place to work that, I hope that, like Barbara said, these 4 years are short, that I hope that this time period, I hope that you consider staying and continuing and accepting the job offers that some of you may have already had. In terms of advice, I mean, just one thing that I can think of, and I'm sure we'll have all our suggestions as well, is just to find really good mentors, because I think the government is a really complicated place, and there are a lot of processes, strategies that, just in any administration that I think folks in government just learn about. And I think finding good mentors to help you navigate all of those complicated, sometimes written, sometimes not written, often unwritten kind of norms, I think will be so valuable. And they will be skills that will last, throughout this administration. So that's just one thought.
Yeah, one thing I would add is just I really liked Barbara's frame around how I would advise my child or best friend in this circumstance. So I think the advice I would have is to wait it out and see, if you're a law student, if you're considering internships, I would still apply to the honors programs, to whatever you are already considering in the federal government, or, consider, still starting in the agency where you have a job. And I would also advise to start thinking about backup options. So if you're a law student and applying for a summer job or the honors program, you will have a lot more information between now and when those programs actually start than you do now. And so I would think about applying to other options outside of the federal government as well, so that you have some backup plans if things are moving in a direction that you just don't think you can, continue. But I would not advise necessarily just exiting, not considering federal options at all. I think there are still a lot of potential options for good service in this administration. And so thinking about, state AG honors programs or other state and local agency summer internships as well as nonprofit groups, so that you have a little bit of optionality once you have to actually make the final decision, I think is how I would advise approaching it.
I certainly agree with everything, well, that's been said, and especially what Jill is saying about really keeping options open and waiting for more information, and just know that there are multiple different paths that can get you to the same place if that is your career goal. And just speaking again on behalf of a government watchdog org, I'll just say that, we have regular high-level meetings with folks, across the federal government, whether that's the Department of Federal the Department of Veterans Affairs, Office of Special Counsel, ODNI, et cetera. And so that's a really great opportunity from outside of the government to get a lot of that deeper understanding, which can be really helpful however your career moves in the forward.
We have a couple of other great questions. That advice is sage. If civil servants do leave, how difficult would it be for them to actually return to federal service later on?
I guess I'll say, I don't think if you leave on good terms and leave on your own terms, I don't think it's difficult to return to civil service. You may not get the exact job you had before. There's no one's going to keep your job open, but if you've worked in the federal government and you want to go back to federal government, as long as it was a voluntary resignation, then I don't think there's any obstacle to returning. And I guess that's something to think about, right? If you are fired for insubordination or something like that, it might be more difficult to get rehired later. But if you're asked to do something you don't want to do, you can choose to resign at that time. And I don't think there will be any derogatory information about you in your file should you choose to reapply down the road.
I think that's helpful for people who are looking for a place to land. We have some really great questions. They kind of run the gamut. And Barb, this might be a good one for you, and maybe Joe might have some thoughts, but what advice do you have for lawyers who find themselves as a part of the apparatus to actually silence opposition? Through reputational injury by like using criminal or civil legal proceedings. Let's say they work in a U.S. attorney's office, or they and they're called on to do this. Regardless of whether those cases are successful, like what advice do you have for attorneys who will be called on to do that?
Yeah, so this is what I think is everybody's nightmare scenario, that the appointees for Attorney General or FBI Director will make good on these vows to seek revenge against political enemies with baseless criminal prosecutions. I would say this, prosecutors are required to follow what are known as the principles of federal prosecution, which lay out the factors that prosecutors should use in exercising their discretion. There should be a provable case. It should be probable that a conviction can be obtained and sustained on appeal. A case may not be based on political association or affiliation in any way. Now, I suppose a new attorney general could change those principles of federal prosecution. They've been in place since the 1970s following the Watergate scandal. But they're there for a reason, and they mirror in many ways the ABA's guidelines that apply to state court prosecutors. And they are the ethics of the Department of Justice. And so if someone were to direct a prosecutor to draw up an indictment against Liz Cheney, you'd have to have a statute that she has violated, and you would have to have evidence to support a violation of that statute on all of the elements of it. You'd have to take it to a grand jury. And so I think I'd like to think that the checks in the system between a grand jury, a defense attorney, a judge, and a trial jury would prevent those baseless prosecutions from going forward. But in the first thing that should stop it should be an ethical prosecutor who would say, this is a baseless case. Or even if, I think about the Hunter Biden prosecution, he was guilty, but it is not the kind of case that would ordinarily, in my view, be brought, because it's not the type of case that is brought against other individuals. And so I think that a good faith prosecutor should raise that with his or her supervisor, and the remedy you have available to you is to withdraw from the case or to resign from your job. We saw that in the first Trump administration. You may recall when charges were filed against Roger Stone. He was convicted at trial, a Trump ally, And then the prosecutors, who were the career prosecutors, filed a sentencing memo that sought a relatively harsh sentence against Roger Stone. And William Barr pulled rank and said, no, I don't think we should seek that much. We should seek a much lesser sentence. And there were 4 prosecutors on that. 1 resigned from the department altogether, and 3 resigned from the case. So that's something you can do. And not only does it free you from doing something you believe to be unethical, but it gets noticed, and the public reported on that. And so that is a way of registering your objection to the use of a political use of criminal prosecution.
So the threat of those ascending to power over agencies is that they will go after the people within the agencies that disagree with them. Let's say, take that example that Barb just gave. Can the heads of the agencies and the political appointees then immobilize the employees of goodwill who refuse to engage in illegal or unethical conduct by suspending them or reassigning them, or trying to move them to a different office or a field office as they're trying to address their rights under the law? And that might be something that Barb or Joe could address.
Go ahead, Joe.
Well, I was going to say, yeah, Barbara's the real expert here. But I mean, one thing, I mean, I think the short answer is yes, certainly, especially with regard to Schedule F and some of these other related threats. At the same time, I think folks who served in the previous administration at high levels, and some of the folks who we know are coming into the new administration have been very clear about not just terminating people's due process protections, but really creating and fostering a climate of fear and retaliation. Russ Vought, who was one of the architects of Schedule F under the first Trump administration, has been nominated to lead OMB in the incoming administration. He's on public record declaring that he wants to put civil servants in trauma and everything like that. I think a lot of the sorry, like a lot of the sorry, let me rephrase this. James Shirk, who was actually the one who authorized or authored the Schedule F executive order, what he has said is, like, when people have brought up, this is estimated to impact tens of thousands, 50,000, 100,000 or more employees, he's been clear about saying, well, it actually won't take that much effort because we'll use a smaller number of people as an example, and then other people will fall in line because of that. And so I think there are the very overt ways, directly taking away people's rights and protections, but there's also just that general shift in agency culture that really cultivates that type of culture of fear and retaliation.
We have so many open questions and we can't get to them all. There's one question I think that some people are thinking about, given the interviews that people are going through for positions in the next administration, is what would you say that to current federal and government employees, if it happens that they will have to prove loyalty to Trump, to his administration, on top of the oath that they take when they sign up for these jobs? Do you have any thoughts about that possibility, and how employees can handle that if it comes to pass?
I guess I'll just say it's such an inappropriate question. I've never been asked anything remotely like that. And I think if I were to hear it, I would be just appalled. But there is some reporting that that's happening. I don't know that it's happening at lower levels. You may recall it happened during the George W. Bush administration. And, Attorney General Gonzalez lost his job over it, that they were asking people political litmus tests. So it's incredibly inappropriate. But I suppose if that becomes the new norm, someone may find themselves in that situation. I mean, I personally would never take any sort of loyalty pledge. Maybe there's a way to answer the question without ruffling feathers if you want the job. But I think what I would say is it's like Jim Comey with the request for loyalty. I think
Right.
the best you can do is to say, I pledge my integrity to the best of my ability. Then that's my job, and that's what I intend to do. I'll take the oath to uphold the Constitution, but not to uphold loyalty to any individual.
I think that's fair. There are two more questions I wanted to get to because it's not just the civil servants. The federal government employs a tremendous number of independent contractors. And I think that the federal contractors are concerned about whether they'll be targeted over the regular civil servants, and if so, do they have any protections that they can leverage in their positions? Maybe Joe might have some thoughts, or Jennifer might have some thoughts. I know that these are tough questions we're all grappling with right now.
Well, I was going to say my immediate response is thinking about this new Doge and the work of Musk and Ramaswamy. And I mean, what they're trying to do is really, gut federal agencies and the federal budget, which would only shift more money towards contractors. In terms of protections, it's been over a decade since the whistleblower laws protecting federal contractors have been updated. That was actually one of our priority bills that we worked really hard on this Congress, thought that there was a real chance of it passing, and then it died at the very last minute. There are some protections in place, but and so I'm not sure if there's a sense that contractors will be targeted more than just employees, but I think similarly, it probably depends on the agency and the issue. I think especially, national security contractors would certainly be an area target for abuse of this.
Yeah, I just add, to Joe's first point about whether to expect, like descriptively, that they will or will not be favored. I mean, there's some empirical work, Rachel Potter's done some of this, suggesting that actually presidential administrations have used independent contractors as a way to bypass civil servants. So in other words, to expect actually that maybe this administration will be turning more to independent contractors. So just to say that there's some studies on that. And then I guess just one thought too about protections is to say the obvious too, that, that like your contractors. So, if there is more demand, maybe there's more strength in being able to contract. I'm not super optimistic, but that is kind of, I guess, another legal mechanism that I can think of.
I'll also just say, I think there may be opportunities for collective action and questions to your employer. If your employer is the contractor with the federal government, to ask how they plan to approach demands from the new administration. And I think just with all of this, there's a lot of bluster and kind of bullying language being bandied about in the press and in behind the scenes reports. But most of this action requires the compliance of people who are willing to go along with it. And so, as we've talked about before, of course, you should be expected as a federal employee to set aside your personal, political views or policy views, but you don't have to be expected, and you shouldn't be expected to set aside your legal and ethical obligations. And so I think it's important to keep reminding ourselves of that there is a lot of bluster attempting to convince folks that they have no recourse, that they have no power, and that they have no choice but to simply comply. And as we saw in the first administration, and frankly, in other authoritarian regimes around the world, it's always more complicated than that. And you do have options, especially if you act collectively with others in your agency, in your employer, in your office, if you're a federal contractor, through whistleblower protections, et cetera. So you do have options.
Yeah, I did want to ask this one last question, but we only have like 30 seconds left. Justice Sotomayor had admitted in an interview that sometimes she goes back to her chambers and cries. And as somebody who worked for an attorney general during the last Trump administration, it can be very emotionally taxing, regardless of whether you're in the federal government or outside the federal government doing public service. Do you have any advice, recommendations about supports for people's emotional well-being while going through this? I think it's incredibly important that people don't exhaust themselves in advance, but you're going to face a lot of exhaustion in the middle of it. Any quick tips for folks who will be going through this?
Not any real tips other than to say that there are a lot of organizations who are really thinking seriously about this, and the best way is to band together and provide this type of support that we're talking about.
So this
So
is not
it
the
is something
end.
that we take very seriously.
Yeah, this is not the end of this conversation. I mean, it will be an ongoing conversation as we go forward in the weeks and months and years ahead. I'm so grateful for each one of you for joining us today and sharing your expertise with our webinar participants. I want to encourage everyone on the call to find your community through the ACS network, with lawyer chapters throughout the country and student chapters at nearly every law school. ACS can connect you with the progressive legal network in your area. And ACS also offers its members career and clerkship advice. You can find more information at the links in the chat. Sorry we couldn't get to all of your questions, but again, very grateful for all of your time today. Thank you so much.